Good afternoon. My name is Mo Sayed. I'm an immigration attorney at Offit Kurman. I'm very pleased that you've joined our webinar. Today's webinar is going to be about the family-based immigration and visa categories and the impact of the COVID-19 pandemic. I know that we're all going through an extraordinary circumstance, and the problem is that these issues that existed otherwise in a pre-COVID world, they have only been exacerbated. So folks, there's still family members that are overseas wanting to come in. There are folks within the US that have pending applications, and the system was not ideal to begin with, and it has certainly, the pandemic has created so much stress, concern, uncertainty. And so my hope in the next 30 minutes is to cover some of the basics and then talk about some specific issues that are going on in the present conditions. So as we normally do, we will be sending out the PowerPoint slides to all of you that have registered by email. And if you are not able to, follow along the slides right now, that you will receive them at the end of this program. I have my email address there on the screen right now. You can certainly email me, and I'd be happy to send you the PowerPoint slides and answer any questions that you might have. So we are welcoming questions as well during this presentation. You can put them in the chat box. If you're using the GoToWebinar interface, there's a chat box that will let you ask questions, and I will be able to see them. And also, I want to say a big thank you to Jennifer Helfand of our office, who has been doing a phenomenal job with putting together these webinars and getting the information out to folks that are finding this information useful. And so definitely want to say thank you to Jennifer. And okay, with that, let's get right into it. Like I said before, the family-based immigration process was not an easy or straightforward or intuitive process. Even before all this recent events happened, all these recent events happened. There was a lot of pressure, delays, backlogs, a lot of lack of clarity, and there were changes that the Trump administration made that had immigration attorneys just basically scrambling to address issues that their clients were presenting. And this, pretty much this shockwave started with the initial travel bans that impacted certain countries. And since then, there's been several court cases, different types of categories of family members that are being treated, due to certain, fact scenarios that create uncertainty for them. So we were dealing with a lot of uncertainty even going into this COVID crisis. It makes sense to try to understand some of the background, and then I'll touch upon what the COVID-19 pandemic means to those US citizens who are petitioning, sponsoring for their spouses, their parents, their siblings, in some cases, adult children, and so forth, and what can be done to plan for the future. So we have the next slide that I have is just trying to move. Yeah, so slide number 3. This is a overview of sort of 8 main areas that I would hope to cover in the time that we have. And the first category that we'll really go into is the fiancé visa. Then you have the marriage-based petition, which is for a green card. And then we have situations where folks petition for elderly parents. You know, there's a large population of expats, new US citizens who arrived to the US from foreign countries and now live here and have their careers here, and now their parents are retiring and back home in foreign countries and they would like the family to be together. And often these parents are living in countries with not so good health systems and quality of life, especially for the elderly. So there's you know, a whole group of folks that are interested in bringing their parents to live in the US. And certainly same type of reasoning for siblings and children. So once folks have green cards, then usually, you know, which is the permanent residence, then they are interested in, you know, eventually becoming citizens. Most folks are, because they want to get some kind of a permanent status here and then sponsor other of their relatives. So I'll spend some time on talking about citizenship. Once folks become permanent residents, they also want to maintain their permanent resident status. So we'll talk some about that. And there's some issues there right now because of travel restrictions. So you have green card holders who are stuck overseas and not able to come back in. And they have certain time restrictions on their travel. So, you know, how those rules will play out with the practical realities, you know, we'll talk some of that. Then there's something known as the public charge guidelines. We'll talk about those. It's essentially a additional on top of the existing income sponsorship requirements. The government has since August 2019 there's a new rule that imposes additional screening based on financial criteria. And then lastly, we'll talk about the delays and the different stages in which delays are occurring. What are the additional COVID-19 related delays, and what are some of the options to expedite cases that are stuck. Alrighty, so with that, let's get right into the first category, which is our fiance base. But before I get into that, I'm sorry, actually, I want to just, this is a overall broad concept that I want you to just keep this framework at the back of your mind. So in our world of immigration law, we view the world in two sets of people. One are those people that are, one set is those people that are already in the US, okay? And they're foreign nationals. They came here on some visa, or they came and overstayed their visa, or they came here undocumented and they're in the US. And they have a particular process for changing or adjusting their status. So when you see this term adjustment of status right here, that means that your subject or your beneficiary is already in the US on some other status, and they're going to be applying through marriage or through employment or through asylum, some other category, to adjust their status to that of a permanent resident. Okay. The next bullet point, the second subset, is it's consular processing from a consulate or an embassy. These are people that are in foreign countries and are applying for benefits there. So they have received, let's say, an approved sponsorship from a spouse, and they are applying now to finalize, get their green card at an embassy. So that's the consular processing, okay? And with respect to both of them, we have updates coming daily, and the USCIS website is a good source for such updates. And almost every day, if not daily, weekly, there's updates on embassy closures. Like most embassies are closed except for non-emergency type of services. So as of now, consular processing is pretty much under lockdown, and we don't know when it will resume. So folks that have, for example, I mean, I have clients that had interviews, their cases were approved, but then the COVID-19 shutdown happened, and folks that had already been waiting for years or months, or in some cases a year or two, have now been put into limbo again. They don't know when this consular processing will resume. The adjustment of status part, which is handled by the USCIS domestically. So the consular processing is handled by the Department of State, under which the embassies and consulates operate. The adjustment of status is handled by the U.S. Citizenship and Immigration Services. They're still operating. However, they have in-person services which are closed until May the 3rd, and it's probably going to be extended. Originally, they had said late April. Now they extended it to May the 3rd, and it all just depends on how everything pans out. Hopefully, we find a vaccine tomorrow, and all of this goes back to normal. But until then, we have to plan ahead. So, okay. So, without further ado, the fiancé visa is slide number 5. So, most of the times, in fact, so as a blanket principle, a fiancé that is already in the U.S. is not eligible for this visa. Okay, this visa is only available to folks that are living abroad and they have a U.S. citizen fiancé and they're planning to get married within the next couple of months. And there's several ways that folks can handle the logistics. It depends on, when the foreign national wants to move to the U.S., how soon, and what their essential game plan is. Okay, so one of the ways in which a foreign national can come to the U.S. to get married to a U.S. citizen is by applying for a K-1 visa. It's a 2-part process. So one part is the U.S. citizen filing a form, I-129F. This form gets filed with the USCIS domestically in the U.S. Okay, certain evidence is supplied with it. That evidence consists of the proof that the U.S. citizenship, proof of the intent to marry, proof of just that they're both single, that they can get married, so prior divorces, proof that there's been an in-person meeting in the last 2 years. And so in order to show that, you have to show travel documents, photos, etc. And this can be hard in some situations. So when all of that proof is put together and the required filing fees and other documents are assembled and submitted, the I-129F is then processed and approved. Can take a couple of months for that approval to happen. With this approval notice, then the fiancé will apply to the U.S. Embassy in his or her home country and apply for a visa. And there's an interview process. There's a affidavit of financial support at that stage, where the U.S. citizen has to show that there's enough financial ability to support this person when they come to the U.S. And when this process is completed, there's going to be an interview at the embassy or consulate, which right now we know that those aren't happening. However, whenever operations resume, an interview will happen, and then a visa is issued. It's considered a non-immigrant visa, and the person can then travel to the U.S. and they have then 90 days to get married, and then continue the process towards getting a green card. And so right now, you can obviously see the uncertainty, because we will probably not get visa interviews, even if that side of things changes. There's some countries have their own domestic lockdowns where there's no flights in or out of these countries. So you know, there's a lot of challenges right now. So okay, so with that background, it's a nice way to jump into some of the other categories. Okay, so let's keep that idea of that affidavit of financial support that I mentioned. All right, because almost all of these family-based criteria will require that document, and I'm sure you all will be curious to know how that's done and what is the process. Okay, so so here what I've done on our the slide that you're seeing right now, the income guidelines, like, so the US government has a set of HHS poverty guidelines, and what a sponsoring US national, or in some cases a sponsoring US permanent resident, has to show that for the size household that will result from the successful visa application of their relative, for the size household, like you'll see this one column says, you know, household from 2 to 8. What is the minimum guideline of income? What do they have to show that they are you know, able to afford? So, or you know, what is the household income to sponsor a person? So so these are, like, say it's a husband and wife, makes it a household a size of 2. So the US citizen has to show at least $21,550 in income. Okay, so these are, you know, W-2 tax returns, pay stubs, income from business. Now, and you know, the larger the family, or the more number of people they're sponsoring, that income threshold goes up. Now, keep in mind that in some cases, if they, you know, they don't have this income, it is allowed for a non-related US citizen to be the financial sponsor. So you would have the family member that's the actual legal sponsor, that they'll remain on the forms as the legal sponsor. And then on the financial sponsorship side, they can have an unrelated friend or a family member to be the financial sponsor. So that's allowed. And this will apply for you know, sponsoring a wife, parent, sibling. These income guidelines apply to all of the family-based petitions. Okay, so now, so I'm moving on now to marriage-based petitions. So these are, there's a lot more to talk about here. And the reason is that, you know, when I said that for fiancés, they have to be outside the US. So that process is basically designed towards folks that will be going to embassies and getting interviews done. For marriage-based petitions, you can have a US citizen marrying someone that's already in the US, or already married to them and they're in the US as a student, or you know, working at the World Bank, or they're you know, here as a tourist, and they decide that they're so much in love and they now want to get married, like very spontaneous, like someone comes for vacation and, you know, they're not planning to get married, but things happen and they decide to get married. So there's a whole process for those type of people who are already here, and then for folks who are outside, there's a whole different set of process. Okay, so now the first piece of both of those is the same. So the first piece is this form I-130 and the form I-130A. At this stage, this is the petition from the US citizen sponsor to, it could be a US citizen sponsor, or it could also be a US permanent resident sponsor. So these two categories of individuals can sponsor their spouses. Okay, so they file these forms, they provide these supporting documents, which are, you know, like the slide says, birth certificates of children together, if you know you've been married for a while, or if you have kids together, photos of the couple together, documentation of what would normally exist with a married couple, like, you know, joint financial documents, health insurance documents, proof of living together, leases, loan payments. Right, these days there's so much of communication online or on mobile devices through, you know, WhatsApp, email, Skype. So, you know, and this is especially relevant if, you know, they're not physically in the same city. So, you know, showing all this kind of evidence is important because there's a lot of fraud in this area, unfortunately. So the USCIS is looking for fraud, and so you know, you have to prove that your marriage is entered into for valid reasons, and so you've got a U.S. citizen or permanent resident, and then you've got the marriage document and prior divorce decrees, etc. So that's the essential packet of the initial evidence. Like, you have religious documents, and there's a whole schedule of documents by country, and so in some countries they have religious, you know, marriage certificates, and the civil documents are very specified. So before doing these cases, one has to consult each different country related Department of State website for certain types of documents, so this is the filing of a marriage-based petition. Now, let's go process-wise. Like, if this is going to be sent to an overseas processing, you know, location, then once the I-130 is approved, which I would say 6 to 8 to 12 months sometimes, it takes that long to process, then it's going to be sent to the National Visa Center, which is like a central location for all these applications. There's a next stage of like uploading documents online for the husband and wife, and then once that's completed, there's some fees paid. The embassy invites the candidate for an interview. Before the interview, they've got to do a medical exam with a State Department specified physician, and prepare for the interview and show up. At that point, the affidavits of support and income proof is also required. So this is how you would do it if you are doing this on a consular processing case. Okay, so now we go to the adjustment of status. So if they're already in the U.S., how do they do this? Okay, now one key issue, like one key advantage for being a spouse of a U.S. citizen, okay, and this is an important concept. So because you have two things at play, like if there's a foreign national that's in the U.S. and they're on a certain visa category that said that I'm just coming here as a tourist and I'm going to go back home when my trip is done, or I'm coming here as a student and as soon as my school's done, I'm going to leave. But if you then turn around and marry a U.S. citizen and apply for adjustment of status, then there's a tension, because then there's a presumption that there was some misrepresentation, that this person had the intent to become a permanent resident at the time that they entered. And so that's a grounds for which the examiner could deny the application. So these are things to be addressed very carefully. Okay, so the intent upon entry is something that has to be demonstrated as like having not been a preconceived idea to enter the US, get married, and apply for immigration. If they're already here and they change their mind, that's fine. Okay, so that's the best case scenario. Like, they came in, they weren't planning this, they hadn't been proposed to, or even if they were going to get married, their plan was not to start living in the US right away. Their plan was to go home, pack up, then apply and have an interview at the embassy, and then come back to the US. So this is kind of like one of the areas that is very important to address. Related area though, like, the biggest benefit, right, of this is that spouses of US citizens are one of the, actually that's the only category where they are not penalized for being out of status. They can be here unlawfully. I mean, they can be here on an expired visa, and they can be they can be in this country without like a legal status, and they can still get married and get a green card. Okay, so I'm going to ask a quick there's a couple of questions coming in, so they're good questions. Let me just quickly address one. Okay, what secures the financial obligation? So this is with respect to, right, the financial commitment for the fiance or spouse. So the form that's signed, it's the form I-864, and so that's the form that contains the commitment. Essentially, it becomes a guarantee. So it very rarely happens, but the government, in the event of a government expense on this foreign national, the government can use that guarantee to collect against the sponsor. But again, it's very rare, and I'm not aware of like a bright line test, but usually when a green card holder will become a citizen after 3 years or after 5 years. So at that point, that obligation then no longer exists. So it's not like it's a lifelong commitment that somebody has signed. So there are time limitations on this, and it also depends on, someone who's a sponsor may lose their job. So I don't think they'll be held to that standard. So it's a good question worth looking into. In my experience, though, I've not really ever met anyone who had a huge financial loss because they became a sponsor on one of these financial forms. Next one I have, so good question. Do all the communications between fiancés need to be provided? Some may be a little off color. That's a great question, because oh my God, there's many fun and funny and unexpected situations about being an immigration lawyer, and sometimes the evidence that I review can be bizarre. So some people want to send videos, people want to send photos, all types of things. I think the rule that I use is that we want to tell like a bit of a biography. Like, we don't want to make it so there's not a requirement to disclose everything. Like, so the attorney and the clients can decide what they choose to show in their favor, right? So I would say things that are favorable and decent should, that an examining officer will find helpful to make his or her decision, those should be shared, but there's no obligation to share everything. I had a case where it was actually, I'm glad you asked the question, because one of the stories I wanted to share was of a fiancé, where one of the challenges in the fiancé cases is that if they're living in separate countries, it's really hard to show that they physically spent time together. So, and I have a lot of cases where the couple has met like very briefly and they talk on the phone or online. They've been dating for a long time online, but they've only met briefly. And so in one case, though, I had a US citizen whose fiance was in Mongolia, and the U.S. citizen was from Mongolia originally, and he had business and property in Mongolia, and so he traveled a lot. And his fiancée and him lived together. So I really liked all this evidence that, hey, they're living together. He travels back and forth, and so there's a lot of evidence. And then prior to filing the case, the guy told me that they've also got a kid together. And I said, wow, that's awesome. Like, send me the birth certificate. And it was a 6-month-old. So I felt like I had a very strong packet now, like with a kid in the picture and a birth certificate. There can be no denying that they had an in-person meeting in the last 2 years. But I submitted the case, and I was just kind of blown away. I got a letter back from the US government saying, you haven't proven to us that they've met in the last 2 years. And I was like, what on earth? But, so they can be somewhat difficult. And so, the way to approach it is to essentially then, okay, look at what other evidence we have, like look at every airline ticket, look at every stamp on the passport, look at every phone call made on a phone bill, and where did the call originate, where did the call, where was it made to, bank records, ATM withdrawals. So anyway, we overcome and got that case approved. But that's the kind of evidence that you have to supply for these cases. So let me another question is that the I-130 instruction specifically requests that we do not send materials that would be considered explicit. Yeah, absolutely. I think you've got to use your judgment, right? So you don't want things in there that are not really necessary. And the typical marriage-based petition, there's a pretty standard set of materials, and there's no reason to go outside of that. Okay, so let me see. I've got another longer question that I'm gonna leave for later. Let me just try to move through these slides first so we can cover some ground. Okay, so back to our slides. So I'm talking about the marriage-based adjustment part. So okay, so we've got the I-130 approved, and now we're filing an I-485. I want to explain some of the process for those of you who may be wondering. So when they're already in the U.S., what happens is that we file this I-485, then and these other applications along with it, which there's a travel authorization and a work authorization. So the I-131 and the I-765, they are important because the overall processing can take a while, like from 1 year to 2 years before they get their green card in hand, which allows them then to leave the country and come back, travel, or to work. Because while all of this pending, they're not allowed to leave the country. So that can pose a lot of hardship. This is where a COVID-19 related issue might come up, because now I have clients that have recently filed these. Traditionally, what would happen is within 4 to 6 weeks, the client would get interviewed. They would be required to get their fingerprinting done, and then after the fingerprinting, 3 to 5 months, they would get the travel authorization and the work authorization. So then, now, even before then, with a pending I-485, they can get a driver's license renewed, okay, but they can't work. Now their status starts to, if they were already in some kind of visa category, they're still considered lawfully present in the U.S. once their I-485 is filed after, it's been pending, if they'd filed it in valid status. So that's an important consideration. However, if they have uncertainty over how long it's going to take to process, this is going to be a tough situation for some people if they need to work, if they have other reasons to travel, even though travel right now is tough because of its own health related risks. But so let's say everything resumes to normal, folks start getting the work authorization and travel authorization documents back in the regular processing time, then usually, I would say between 8 to 12 months after that is when they would get a interview for their I-485, and then get their permanent green card. And usually they had interviews done. Now there's not, the interviews are not happening, the biometrics are not happening. So I have heard from some of my colleagues that they've had cases approved without interviews for spouses and for parents, and even some employment-based cases. So that's good. But I believe that the biometrics requirement has still not been waived. If they already have biometrics from a prior application, then they can reuse those. But so I'm not sure that for those that they don't have biometrics for, if they're going to waive that requirement, which will mean that there's going to be an indefinite delay until the offices open back up again. Okay, so I think we've touched upon this slide before. The legal status in a marriage case to a U.S. citizen is not, it does not disqualify. There's a question, like people ask, like how soon can I get married after I come in as a visitor, or like how soon can I apply after I got married? There's not really any bright line test. The State Department has a rule, a 90-day rule, which is, it's not really a USCIS rule that applies to adjustment applications, but it could be somewhat, it could influence USCIS. State Department will look at this in terms of like if they're approving a new visa application in a foreign country, they may look at the prior history of a person and say that, like, let's say you went to the US as a tourist and then the next week you became a student, so that's a violation of the 90-day rule. That you the fact that you change your status so quickly means that you're not complying with the original intent. But if you're beyond 90 days and you do a change, then you're okay. So I tend to be conservative. If I have the flexibility to tell a client to, like, hey, just wait for 90 days before you do any change, just to be safe, so that there's no questions asked and additional bureaucracy. So there's some consideration on timing. So I wanted to just state that. Note that you have a difference between when there's a person that applies for adjustment that is in the US on a visa, which is like a student visa, a tourist visa, or work visa, versus they're from a ESTA country, or like, which is a visa waiver. Like if they're like from one of the countries with which the US has a visa waiver program, where, let's say Germany, they just get a ESTA, it's electronic authorization, and they can come into the US, so it's not technically a visa. Just a word of caution. So folks that apply from certain visa categories to adjustment, if there's issues, denial, or if there's like pushback, there's a denial and then like an appeal type of situation, I'm just speaking very generically, they have the right to a hearing before an immigration judge, and they can make their case again, and perhaps in most cases convince them to grant the benefit. ESTA visa holders do not, sorry, ESTA holders don't have that. So the visa holders have additional protection that ESTA folks do not. So you got to be careful in making the decision to file. So okay, now let's say we're done. We have got an approved green card, and if it's the one that's through marriage, then it's a conditional green card, right? So because there's this heavy prevalence of fraud, unless you've been married for longer than 2 years prior to applying, you get, in which case you get a 10-year permanent green card. But if you've been married for a short duration, you'll get a 2-year conditional green card, which after 2 years of marriage, you have to go and renew, okay? So the conditional green card has to be renewed after 2 years. If it's successful, then that you get a 10-year permanent green card, and then you can apply for citizenship, etc. Okay. Before filing, it has to be very seriously the prospect of being stuck in the U.S. unable to travel is a serious thing. So after these petitions are filed, until a travel document is issued, one can't travel without abandoning the I-485 piece. Okay, so just something to think about. Okay, let's see. We have try to move through some of these slides quickly. So parents, siblings, children, very similar to spouses in terms of the overall process. The only thing to keep in mind is that there are different time frames, and for these folks, it's important if they're going to adjust status for them to be in valid status in the U.S. So whereas spouses do not, if they're spouses of U.S. citizens, parents, siblings, children, which are adult children, they have to be in valid status. There's a whole schedule for timing of how these, depending on what country you're from and depending on what level of relationship we're talking about, there's a schedule of how quickly they're processed and approved. So I'll take you to that slide. So this is something known as the visa bulletin, and this tells us every month the timelines of processing. And this website, if you just Google visa bulletin, it's going to pop up. And so here you'll see the categories of family sponsored that have different processing timelines. So the quickest one is unmarried sons and daughters of U.S. citizens. So those are the children of U.S. citizens that we talked about. Then you have relatives of permanent residents, and so there's all this like different classifications. Okay, so once you determine whether it's F1, F2, F3, F4, then you go to this slide, which is which gives you that, if you're sponsoring an F1 relative, and if you're not from one of these other countries like China, India, Mexico, Philippines, then between 2014 and 2020, there's about 6 years of a wait, right? So this usually for the children and the siblings is where these long waits come, right? So you're looking at 6 years, this is a long time, 13, 14 years for, siblings. And if you're from one of these countries, some of them can be very backlogged. Okay, so that's the only big difference. And that also the difference is that then these people can't get work authorizations, these people can't get travel authorizations, etc. And they can't adjust. They have to apply for these visas back in their home country, except for the parents. So parents are in that sense similar to spouses, but they still have to be legal when they're applying. Okay, so that's the visa bulletin and these priority dates. And so let's move to, okay, so I'll try to move through this quick, and I know you'll have specific questions, so please ask me later. But hopefully the green card process, the permanent resident process, hopefully I touched on all the major issues there. So now, once you have someone that's become a permanent resident, there's two categories of waiting times. So generally, once someone has a green card, they've got to then wait for 5 years to elapse from the date that they became a legal permanent resident or LPR, and be physically present in the US for 30 months before applying. Okay, so that means within those 5 years, they have to be in the US for 30 months, and then they can apply for citizenship and they can apply a little bit before. They don't have to actually wait for the 5th anniversary. They can apply, like, I believe it's 90 days before, and submit the application for citizenship. Second scenario is if they're married and living with a U.S. citizen, married to and living with a U.S. citizen, then they have to show 3 years of being a green card holder and 18 months of physical presence in the US. Okay, so the process is that once these conditions are met, a form N400 is filled out with supporting documents of the green card, the marriage certificate, the proof of the in case of marriage cases, and then if you're showing the 3 years in marriage to a U.S. citizen, then you've got to show that you've been living with the U.S. citizen, and then show 18 months with them in the U.S. And for the 5 years and 30 months, it's basically your green card, and then tax returns. What are you living and working in the U.S.? Where lease documents, utility bills, things like this. So file the N400. Then there's initially a biometrics appointment in 6 to 8 weeks, and then there's an interview anywhere between 8 to 12 months, I feel, and then there's a oath-taking, swearing-in ceremony. So then once they get their citizenship certificate at their oath-taking, and then they can apply for getting a passport. So that's citizenship broadly. Now, some issues come up, right? Because you have a, the issue that comes up is that some permanent residents don't have the physical presence in the U.S. for whatever reasons, and they still want to go become a citizen. So some of those cases are, this was a timeline, so we covered that. So maintaining permanent resident, right? So that's what we're talking about. So in this area, and it's important for many reasons, like some people don't want to become a U.S. citizen, but they want to keep the green card. Some people, have a compelling need to go overseas, but yet want to become a U.S. citizen. And some people actually, after a while, they actually want to give up their green card, and for tax reasons, they don't want to pay U.S. tax, because that's one thing they need to know, that once they are a green card holder, they're taxed on worldwide income. So some people actually want to give up their status, and there's a process for doing that. But folks that do travel outside for long periods of time, when they return, especially if it's more than 6 months of travel outside, when they return, there will be a interview and typically a careful scrutiny of some of these factors, which is like, number one, the length of time they were away. Why were they traveling? Like, was it to care for a sick family member overseas? Was there some emergency? Was there like a fixed date of return to the U.S.? Have there been even if they're, let's say, abroad for a short duration and then they keep coming back and forth, is there a fixed date that they're going to move back and give up the foreign residence? Do they have have they continued to file tax returns? Have they kept bank records, property? Where's the rest of the family? Where's the primary employment? These are things that are important in persuading the examiner that they have not abandoned their residence. My recommendation is that if someone travels abroad for more than 1 year, they should consider getting a re-entry permit. They have to apply for this while they're still in the US. And this allows them to stay outside, no questions asked, for 2 years, and they can try to renew it. Although after after 4 years, I feel that it's hard to renew it. There are some exceptions for spouses of U.S. citizens that are working abroad, or LPRs that are working for U.S. employers abroad, which means two things. Like, one is that their period of residence overseas is not counted against their U.S. stay requirement, and if they're returning to the U.S., the being in a specific type of reason of being abroad will not basically impact their reentry negatively if they're in certain specific categories. So some of it is like staff of U.S. embassies or folks that are working for large U.S. companies and their permanent resident spouses are accompanying them. And so it's a detailed sort of analysis. I'll just leave it in generalities. I can answer specific questions if folks have later. This slide has some of the exceptions. This applies directly to the seeking what's known as to preserve residence abroad for citizenship. So if you're in one of these categories, you have to, like these categories on the slide, if you feel like you're traveling abroad for one of these reasons and you have a green card right now and you're going to be abroad for a long time, provided you've been in the US for 1 year already since becoming a green card, you can apply for something known as it's like an application to preserve citizenship, preserve residence for citizenship. And that way, the time that you spend abroad can be counted as time in the US for citizenship, okay? So my next slide is, I'm afraid we don't have a lot of time to spend on this important topic, but so, you know, we've talked about the income and financial support issues on these applications. So what you have probably heard about is the new public charge guideline and income-based criteria. So in August of 2019, we had a rule that said that if someone's applying for admission or adjustment of status, if they're likely at any time to become a public charge, then the USCIS can deny them the benefit. And the factors that are considered is, for example, if they've received any kind of a cash or non-cash benefit that's been provided on a means-tested basis. Like, so most commonly they refer to federally funded Medicaid, and does not include certain state-funded benefits that are not funded by Medicaid. So this has created an additional level of investigation by the attorneys and clients to make sure that, like, to protect our clients so that they're not at sort of risk of being denied based on public charge. And unfortunately, right now, this is being applied for like some set of benefits related to testing for COVID-19. So while USCIS will consider, I suppose that an argument could be made that this is a humanitarian situation that should be, you know, forgiven. But these guidelines have recently gone into effect, and there is also litigation around these in several, you know, courts. So it's been up and down, and there's been Supreme Court decisions here as well. And now with COVID, it's kind of like a big mess. But, you know, again, the conservative approach is best, especially if folks are, you know, going to apply for immigration benefits. But we'll hope to get some more clarity on this, you know, in the weeks to come. So just keep in mind that this is an important area when it comes to folks that are here on visas or folks that are here, you know, planning to apply for a green card. So they must consult with an attorney to make sure that there's no risk areas created by the public charge rule. Okay. Let's see, next slide. Okay, so I'll spend just very briefly on this, right? So when you have a situation where you've got a delay, like, so there's a delay with an embassy or there's a delay with the USCIS, in the initial, so for some of these benefits, there are published timelines. Like, there's a website that says case processing timelines, and you can go and see, like, if you're in a particular state filing for a particular type of application, like, so for family benefits, it would be like an I-130 or like an I-485 or I-129F. With the case number that you get, you can go and check for that office what the processing time is. Okay, If you're more than 30 days or 60 days outside of the normal processing time, the USCIS system itself allows you to submit a electronic request or a request by phone to force them to send you an update. Sometimes they work, most of the times they don't. Next thing is that we submit sometimes if we have strong evidence of a financial, health, or humanitarian reason to expedite. There's a statute that provides these criteria to expedite. If we meet any of those and we have a very solid set of documents, we can send it in to the USCIS. They keep changing the process of how it's been done. But sending in a request by fax, by email, by hard copy mail, sometimes over the phone, does help expedite certain matters. Okay, if that doesn't work, I always recommend to my clients to contact their local senator or congressman, and I offer this assistance myself, like to be the liaison to help them to create this kind of a request letter with all the appropriate information so that it's done effectively. And then what happens is that the senator has dedicated staff that are really good, very helpful, I found. And they're going to write to either the Department of State or the USCIS and make an inquiry of like, okay, what's taking so long? In some, not all, in some cases, I would say, maybe a third of the cases, I have seen this speed up the process where the senator request goes out and the case is approved. So those two are good. Like, the senator and congressman, I highly encourage them if you've had a delay of several months and nothing's happening. Last resort, filing a federal lawsuit. I've done this, I'll usually have like maybe like a dozen in a year. And what happens here is that the hope is that there's a statute which requires the government to act within a certain number of days on a pending application. So if a client agrees, now with very, very, very careful screening, you do not want to file this lawsuit if your case has some major weaknesses or a risk area created by, you don't want to file a case that the government's going to fight. Okay, if we're pretty sure that it's a clean case, we file a lawsuit. Usually the government has 60 days to respond. And my experience has been is that the government's going to call me and ask for an extension, which is fine to grant them, and have some discussion about, hey, can you tell us where you're headed with this case, right? Is it going to get approved? What's the holdup? And they can usually give some guidance, or at least say, okay, my client is the USCIS, I will contact them and find out and I'll get back to you. And then in this conversation, you can get an idea of like, is this case going to be litigated forever, or is it going to get approved? So then usually in many of my cases, there's been a few exceptions, just very, very slight, where I didn't get a good outcome, but in 95% of my cases, the benefit was approved within 2 months or so after filing the case. All right. So that's called as a writ of mandamus, and so that's also something you want to consider. And if there's protracted litigation, that can be expensive, but certainly it has to be. It is a good option to use in case there's a very unfair, wrongfully delayed application, right? So, okay, so let me see. I had one or two other slides. I'm going to skip this, I think. I mean, so you will get requests for evidence on your initial petitions, right? So be prepared. Okay, this was some guidelines for consular processing, the kinds of things that take place over there in terms of background checks and administrative processing. That's administrative processing is one of those delays that I'm talking about. Like sometimes everything's approved, the interview's successful, and they say, all right, we're going to let you know our decision. We're doing administrative processing. And it's really hard to know what that means. it can take like months and months sometimes, or stuck for 3 or 4 years in administrative processing. So now with COVID-19, my guess is that they're going to have more delays because they don't have staff there at the consulates, and it's really a difficult area to predict right now. Okay, so let me just, I know we've gone over our time. Let me go real quick to some of the questions. So there's one question is, when can you apply for a parent or sibling? So these are when you become a citizen, is when you can apply for a parent or sibling. So you can go back to the chart that I had, right? So the family-based categories, let's see this chart. So when can you apply for a parent or sibling? So I'm pretty sure that those are, okay, citizens are allowed for sure, we know that, okay? Now, are permanent residents allowed? Yeah, so no, siblings are only of US citizens, okay, that's down here. And then the permanent residents are allowed to sponsor their spouses, okay, children, okay, so that's permanent residents, spouses and children of permanent residents, sons, daughters, okay, so yeah, so you have to be a citizen before you can sponsor a parent or sibling. Okay, one more question. The question is, what does the biometrics consist of? So it's really, they take your fingerprints of like both hands and they take a photo. I've had some situations for elderly people, very old people, whose fingerprints are hard to take, and so sometimes then they have alternatives. They have to go and get police reports saying that they have no record. But that's what the biometrics is, just like fingerprinting and photographs. Okay, there's a question. I heard with an approved I-131, applicant might get denied when they try to re-enter for their AOS. What's your experience on this? That's a great question. I mean, I think a lot of these questions come from the travel ban and certain countries being on travel ban list. So if I have a travel ban person, I may be a little more conservative. Now the I-131 is like the advanced parole or reentry permit that folks get when they apply for marriage-based adjustment and they can travel. My own experience has been good. I've not had a problem at all. What I normally do is I give them a letter. I explain why they qualify for the benefit and why their reentry, their parole back is legit. And I give them my cell phone, and if they have issues, I tell them to give them a attorney authorization form G28. To explain any issues. I think depending if the I-130 is on a work-based petition, they must show that the I-131 that they're still working, that they're still employed in that position where they said they were, or if it's a family-based, then that their family is still in the U.S. and that their underlying petition is still ongoing. So I personally don't think it's an issue, but it's a case-by-case determination. They should not abandon their ties to the U.S. and the length of travel should not be one that indicates that basically they're not interested in pursuing their main application. So my own experience has been good. Okay, we have a couple of more questions. Okay, the question here is, a U.S. citizen got her I-129F approved for her fiance in Trinidad, but it turns out that her fiance got an arrest record 20 years ago of marijuana possession and has since been pardoned. Her fiance has no other violation and has been working in the local government there for past 8 years. Is there a waiver available to overcome her fiance's bar of inadmissibility? This one's going to take a little bit longer to answer. I would like to answer it, but so if whoever asked this question can contact me offline, I will be glad to assess the waiver situation. Okay. Let me see. I'm glad there's so many questions. That's really good. Hold on one sec. What is this? Yeah. Okay. So, do you know the current situation with CEAC uploading civil documents for employment-based IVs? Yeah. So, a lot of folks are having issues with CEAC website, so I wouldn't be surprised. I haven't done one within the last few days, so I personally don't know in this specific instance. I think the idea of emailing them to just nvcelectronic@state.gov, I can double check that email if you just want to send me an email. But that email does look right, and I mean, I don't think there's any harm to apply. To email the documents in that way. I would also try the main. There's a messaging system internally. I would try that as well. But I can try to find out for you and get you a better answer. I'm honestly just not sure right now. But I have heard from colleagues that CEAC is having a lot of glitches. Okay. All right. So, well, thank you so much. I hope that was informative. Certainly, really appreciate the questions. And if there's any topic that you want to address for future webinars, please, let us know. I will be presenting next week on EB5 Investor Immigration Program. On the Investor Immigration Program, there's some changes and updates, and it'd be interesting to see what the impact the recent pandemic has, because there's certainly, this program is designed for economic stimulus, and to the extent that I'm sure we'll need a lot of stimulus when this is done. So there may be an uptick on EB5 investment. So please stay tuned for that. Here's my contact details. Reach out. Thank you so much. Thanks again, Jennifer, and thank you all for joining. Be safe, and hope that you all take care and have a good rest of the day and week.